Lord, shortly before we broke, the question arose as to whether the Article 64 criteria had been met so that the preference shareholders had the votes. I said to your Lordships I would take your Lordships to the evidence which dealt with that. And if I can ask your Lordships to look at page 323. The evidence of Mr. Penner, who's one of the two joint official liquidators, in his first affidavit sworn in the, if I can put it this way, the bias proceedings in November 2014, he deals at page 300, the affidavit starts at 319, but at page 323, he deals with, at paragraph 8, what had happened to the ordinary shares. He says, at the time of the JOL's appointment, the company's ordinary shares were held by QGen, a company incorporated in the Cayman Islands. The appellant was the sole director and ultimate beneficial owner of QGen. And then he puts a footnote there, pursuant to Article 64 of the company's Articles of Association, QGen ceased to have any voting rights as a shareholder of the company with effect from 6 June 2013. From which point the company's preference shareholders became the company's voting shareholders. And that's a point which has never been disputed by Mr. Almazeedi at any point. The issue arose as to what the interest of Qatar National Bank was. And my Lords, it's 7%, as my Lord Lloyd Jones said, and the evidence for that is at page 1088. In the first affidavit of Mr. Almazeedi in the petition proceedings. And one other point which I'm asked to inform your Lordships of on instructions is that I understand from the middle of November the Chief Justice assigned this case away from himself to Mr. Justice Parker in the Cayman Islands. So that simply follows on from the point which arose when my learned friend was raising.
From when?
15th of November.
Yeah.
Most recently, 15, this year?
Yes, this year, my Lord, yes. Yes. I think we were very recently aware. It's not in evidence. That's why I give that information on instructions. The appellant raises a number of points in the course of this morning and in his written case. And where we started this morning and in his written case was with the complaint that the approach taken by the Court of Appeal in the Cayman Islands deprived Mr. Almazeedi of making the Mr. Kamal case, as opposed to the Mr. Al-Imadi case. And my learned friend started his submissions, or at some stage during his submissions, he said, well, Mr. Kamal is every bit as involved in this case as Mr. Al-Imadi. And what we were taken to, what your Lordships were taken to, ultimately was the fact that Mr. Kamal was the Minister of Finance at the time of the petition. And then what was thought to be suggested was that he was also involved in what my learned friend called these proceedings. And my learned friend draws a broad brush when he talks about proceedings. There is simply no evidence of any...
Isn't he chairman of the bank?
He was chairman of the bank.
Yep.
At the time of the petition. But of course the bank was a 7% shareholder, which was not a petitioner.
No.
It was simply a supporter from the outset as opposed to a late supporter. Mr. Almazeedi has never made any case to suggest that there's been any involvement in the proceedings. And what I will be submitting in relation to the fair-minded observer is that for Mr. Almazeedi to conflate the government entities and members of the Qatar government in the context of this case suggests that members at a high level in the Qatar government are interested in matters of detail in relation to an investment in BTU Power Company, which must, in the scale of Qatar, be a very small investment. But what Mr. Almazeedi has not done in relation to Mr. Kamal is point to any involvement in these proceedings which are concerned with the detail of the investment, that is, how is the company being run, do the shareholders have confidence in its management. And the best my learned friend can do is invite your Lordship's attention to a letter written in 2009, which is written to the whole board at QNB, and makes a complaint about Mr. Almazeedi, which Mr. Kamal then passes on to Mr. Almazeedi. And we saw that letter. And there's only one point I'd like to invite your Lordships to consider in relation to that letter, which is right at the back, well, it's at page 1487. And as my Lord Hughes pointed out, it's written to the whole board of QNB, and it makes a complaint about Mr. Almazeedi. And while our broad submission would be that it's hopeless to suggest that this letter and its response would be considered to be active involvement in these proceedings with a view to putting pressure on Mr. Almazeedi in the petition proceedings. It's interesting that in making his complaint to Mr. Kamal and describing the relationship between Mr. Almazeedi and the company and QNB, he attributes the whole deterioration of the relationship to Mr. Almazeedi. He says at page 1489, right at the top of the page, relations between my firm and QNB, however, took a sudden and severe turn for the worse with the appointment of Mr. Almazeedi. And the object of his letter, it would seem, is to write to those who weren't involved with Mr. Almazeedi in the things that Mr. Almazeedi is complaining about, and drawing them to the attention of the board, and asking the board, including Mr. Kamal, to do something about it. The response from QNB, and this is 2 years before the petition is presented, is, in our respectful submission, entirely measured. The fact that it's copied to Mr. Almazeedi is entirely to be expected. And the last sentence, which my friend relies on as being in some way a veiled threat, is no more than one would expect from a person in Mr. Kamal's position, which is to reserve the position of QNB as to its reputation and interests. If Mr. Almazeedi makes allegations of the kind that he has. And in our respectful submission, what that shows is, in fact, that Mr. Kamal has no particular axe to grind so far as Mr. Almazeedi is concerned, assuming for a moment that Mr. Almazeedi does for the purpose of the petition. And it relates to something that happened 2 years before the petition. It relates to a complaint that has nothing to do with the petition.
Well, except in the sense that the breakdown of relations is part of the picture which justifies the dissolution or the winding up order, sorry.
It's a small part of that, if I can respectfully put it that way, because at that stage, QNB are not petitioners. QNB have asked for an exit from the investment, which the terms of the investment don't provide for. Mr. Almazeedi's case is that the $31 million he spent was all spent to try to create a separate entity which would enable an exit for QNB. The preference shareholders don't accept that. But so far as the petition was concerned, which was presented 2 years after this exchange of correspondence, it was focused on what we would submit are the sort of complaints that very often arise in investment vehicles where there are investors who have no direct control over the management of the company, and they rely on the articles and the provisions in the articles for information to be provided by the company. When it isn't provided, they become concerned, and the petition is in our respectful submission, firmly based on the conduct of the affairs of the company, and not on, if I can put it this way, an emotional response or atmosphere that had been created between Mr. Almazeedi and Mr. Almazeedi.
But I mean, the fact is that, I mean, you say it's a neutral response. The letter written is raising a large number of serious allegations about QNB's activities and motives and the effect of them. And the letter coming back from the chairman of QNB entirely endorses QNB's stance. It says the board was extremely surprised and disappointed to receive your letter, which makes a number of serious and potentially defamatory allegations about officers of QNB. While QNB, of course, takes any genuine complaint seriously, it cannot meaningfully respond to unsubstantiated allegations of this nature, etc., etc. I mean, Mr. Kamal and the board is undoubtedly taking the exact opposite side to Mr. Almazeedi on the subject matter of QNB's activities.
Well, it's a robust response, but the thrust of it is to say, well, we've asked for an exit, and it would be better if we concentrated on that. But in our respectful submission, to base the suggestion that if Mr. Almazeedi had known that the Court of Appeal were going to take the view they did, that after 26th of June 2013 matters changed completely because of Mr. Almazeedi, that they could have made, Mr. Almazeedi could have made a case of just equivalent force in relation to Mr. Kamal, which would have shown the Court of Appeal that the turning point didn't come in June 2013, but existed right from the commencement of the case. This, in our respectful submission, is a very thin basis for making it, because apart from responding to a letter, Mr. Kamal is not said to have done anything. There's no suggestion that he's made any threats.
You may be personalising it a bit, and of course that's inevitable in the light of the line which the Court of Appeal drew. But I think the way to be put against you would be to say that the dispute was between basically the Qatari preference shareholders, supported by one of them, namely QNB, and it was personalised to a degree, but if it had been realised that the Court of Appeal was going to draw that personal distinction, it would have been pointed out that the dispute went back to a time before Almazeedi's involvement, and if you look at it in personal terms, that Mr. Kamal was involved at an early stage, and he was continued to be a key representative of QNB, and was moreover actually the father-in-law and a close ally of Mr. Almazeedi, so that it would be unrealistic to distinguish the two periods.
Well, the Court of Appeal took the view that there was a position while Mr. Almazeedi was had a position, was an officer of certain Qatari companies and was an aggressive litigant, which existed from the date that the petition was presented, if not before, and that, for the purposes of the Court of Appeal's analysis, was not sufficient to cause the independent, informed observer to consider that there was a real possibility of bias. It was when the aggressive litigant involved directly with Mr. Almazeedi also then became a minister in the Qatari government with a role in the terms and conditions of the appointment of judges and as part of the council which could dismiss judges. So in our respectful submission, Mr. Almazeedi always made his case on the basis of Mr. Almazeedi being, if I can put it this way, that the principal focus of animosity. And the Court of Appeal understood that very well, and took the view that until 26th of June 2013, when Mr. Almazeedi became the Minister of Finance, that was not something that the fair-minded observer would treat as satisfying the test for bias in Porter and McGill. And in our respectful submission, if the Court of Appeal had been told that Mr. Kamal was the Minister of Finance, that wouldn't have led to the Court of Appeal immediately saying, oh, well, there was a real possibility of bias from that point. They would have said, well, Mr. Kamal has no involvement of any kind or participation in these proceedings. He's not named as somebody who is involved or has an animosity to Mr. Almazeedi. Mr. Almazeedi knew all the facts in relation to Mr. Kamal. He didn't know approach the Court of Appeal would take, but he could have said anything he wanted to about Mr. Kamal all the way through. This new case on Mr. Kamal is, in our respectful submission, an improvisation designed to put together certain, in our respectful submission, inconclusive and ultimately not particularly weighty points in order to try to say that the reasoning of the Court of Appeal would have been identical but would have been backdated.
We don't seem to have any skeleton arguments put before the Court of Appeal on this, or do we? We've got lots of affidavits. I don't know which is the clearest to
Yes.
indicate it was being put in a narrow way, but we don't seem to have got the skeletons, or if there were any.
No, there certainly were skeleton arguments.
There are some of the
Perhaps
skeleton arguments. In fact, not the final skeleton argument, but
Yes, we have. We've got them in 1B.
Yes. Well, we've got skeleton arguments in relation to costs at 24.
No,
905.
bundle 1B, I think.
127.
127.
Unfortunately, we have no transcript of the hearing. But it would do an instant word search.
there is a reference on page 136 to the Minister of Finance. It's at the bottom of the page.
Yes.
And there are various references to the Qatari authorities generally.
That's Mr. Almazeedi, is it, the Minister of Finance there?
Well, he wasn't identified by his name at that point, but that's who it is.
Yeah.
Reference there.
But as I recall, there's no reference to Mr. Kamal so far as the factual.
Well, he's referred to in the affidavit I took to you this morning.
The point we make is that there is no allegation of involvement of Mr. Kamal in the petition proceedings at any stage. What is relied upon is that he was the Minister of Finance in November 2011 and that he was a relative of Mr. Almazeedi's and that he wrote a letter in response to a complaint from Mr. Almazeedi in 2009. And in our respectful submission, the approach of the Court of Appeal to those facts would not have been to change the view they took. It was a combination of Mr. Almazeedi's role as an aggressive litigant, the connection that was drawn between what Mr. Almazeedi did and what Mr. Longmate did in the plane on the way back from Cayman to Miami, and the fact that he was a Minister of Finance, a role under Law Number 7 in the appointment, or certainly the terms and conditions of appointment of judges and their removal. And so when one is looking at the petition proceedings, which in our respectful submission is where to look, because we do respectfully submit that this court should not treat the entire history from the formation of the company as a David and Goliath struggle between Mr. Almazeedi and the Qatari interests. It was a company set up by Mr. Almazeedi, which invited investment from certain interests, 60% or 59% of which were Qatari. There were disputes in the early days between Mr. Almazeedi and his co-director, Mr. Hayat, in which Mr. Almazeedi was involved. Those were acrimonious proceedings, but they're not the subject matter of the petition. and their proceedings, in our respectful submission, should be treated as distinct and separate from the petition, and the focus should be on what the petition was about. And the petition was, we would submit, a relatively conventional sort of petition in this kind of field, where investors had lost confidence in the management of the company, and they gave good and cogent reasons for that loss of confidence in the petition. And they relied on those matters for the purposes of getting the winding up order with the consent of all the parties involved. And where my learned friend overstates the case about Mr. Kamal was one where he caught himself overstating it, as he put it in his submissions. He said Mr. Kamal is every bit as involved as Mr. Almazeedi. And then he said, well, in my note, not every bit as involved as Mr. Almazeedi, and that's the key in our respectful submission. Mr. Kamal was not a focus of any submissions in relation to the possibility of bias in front of the Court of Appeal. And he's only come into focus because the petitioner is seeking to justify the appeal on the basis that the Court of Appeal would have taken a different view with Mr. Kamal in the frame.
Nevertheless, the sort of dichotomy that you're creating between Mr. Almazeedi and Mr. Kamal may be a bit unrealistic. Son-in-law, father-in-law, Mr. Tregear.
In the context of what seems to have been a personal animosity between Mr. Almazeedi and Mr. Almazeedi, we would submit one shouldn't infer that father-in-law is going to be on the sidelines cheering along his son-in-law. The likelihood is it's a private spat, if I could put it this way, between two individuals between whom there is a very poor relationship. But the suggestion that that infects his father-in-law, or indeed then infects the very highest levels of Qatari government, is, in our respectful submission, slightly far-fetched. And one of the things the fair-minded and independent observer doesn't do is follow up conspiracy theories or adopt conspiracy theories of the person who's complaining about bias. These matters will be analysed. And in our respectful submission, if Mr. Almazeedi had considered that there was a case to be based on Mr. Kamal before the Court of Appeal, it's very strange that he didn't choose to make it until now. It would have been a case to be made. There was the Minister of Finance in cahoots with his son-in-law, personally involved in the proceedings. There is no evidence of that in our respectful submission. What one has...
Sorry.
No, please.
During the first period, QMB had a 7% shareholding in BTU.
Yes.
Mr. Almazeedi was the chief executive of QMB, and
yes.
Mr. Kamal was the
chairman of the board.
Was the chairman of the board.
Yes. And well, that is why, or at an earlier stage, it was to Mr. Kamal and the members of the board that Mr. Almazeedi addressed his complaint. It was because in 2009 there was Mr. Kamal, and he was being asked effectively to deal with Mr. Almazeedi. But by the time one gets to 2011, the role of QMB is not as a petitioner; it simply supports the petition. Mr. Kamal is not alleged to have done anything in any way directly with Mr. Almazeedi. He is simply pointed to as a figure who was the chairman of the board in 2011. But we would respectfully submit that taking a perspective, this investment would, for QNB, and certainly for QIA, be a very small one. The only person who would be likely to take any interest is the person who has a relationship of some animosity with Mr. Almazeedi. And the only person who's been identified as having that relationship is Mr. Almazeedi. Mr. Almazeedi hasn't sought until now to make any case against Mr. Kamal in relation to any personal relationship. Indeed, in his letter, he says, my relationship with QNB was very good until Mr. Almazeedi came along, from which one can infer that while Mr. Kamal was in the saddle and before Mr. Almazeedi got involved, there was no animosity between them at all.
Mr. Almazeedi's stance and his vigorous pursuit of the litigation later was taken on behalf of QMB, wasn't it?
Well, his vigorous pursuit of the litigation amounted to no more in this case than supporting the petition. Because what is alleged against Mr. Almazeedi is he made a threat in 2007 in relation to entirely separate litigation involving the placement agent In relation to the petition, he has no particular role, except the Court of Appeal took the view that Mr. Almazeedi's threat was significant in 2007, and they conflated that with the rather aggressive behaviour of the lawyer on the plane back to Miami. But Mr. Almazeedi clearly was acting on behalf of QMB, but the idea that the board of QMB are adopting, if you like, the state of mind of the person who is responsible, or may be responsible, for guiding QMB's role in relation to the petition. There's no reason in our respectful submission to attribute to the whole board of QMB the animosity of Mr. Almazeedi, if that's what it was. But what the Court of Appeal was struck by was an aggressive pursuit of litigation and a position of power in Qatar so far as the judge was concerned. And in relation to Mr. Kamal, there is no suggestion in our respectful submission of any aggressive pursuit of this litigation. The only suggestion is that by association, by relationship, he must be taken to have adopted the position of his son-in-law. There's no evidence of that, and no reason why the fair-minded observer would conclude that that should be the case. My learned friend uses the word involvement in what we respectfully submit as a very loose way. We will certainly be submitting a fair-minded observer. It does have an eye for detail. It's not necessarily going to take a very broad brush approach in the way that Mr. Almazeedi does. And so we respectfully submit that what is said about Mr. Kamal does not get anywhere close to justifying a conclusion that he is involved in the litigation in any more than a nominal sense in the chairman of the board of a company which is a supporting petitioner or supporting the petitioners, or that he has any role in that litigation which could be classed as aggressive. And in our respectful submission, the attempt to, on receiving the Court of Appeal's judgment, simply to substitute Mr. Kamal for Mr. Almazeedi, failed in the evidence and the facts which are capable of being known by the fair-minded independent observer. And in our respectful submission, in any event, and I'll come to this in a moment, we will need to consider law number 7 in Qatar, because the Court of Appeal certainly took the view that the Minister of Finance was closely involved in the appointment, terms and conditions and removal of judges. But we'll look at law number 7 in a moment. It's not as clear as that, and in reality it is the Council of Ministers who have a role in the removal of judges, and the Minister of Finance only has a role as part of the Council of Ministers or as the person proposing the terms and conditions of the appointment of the judge. So we respectfully submit that the new case on Mr. Kamal doesn't work, and it doesn't enable my learned friend to say, well, it's exactly the same reasoning that the Court of Appeal applied at paragraph 89, where they said a position changed. It's impossible for my learned friend to say, well, the position didn't change because Mr. Kamal was involved from the date of presentation of the petition, and he's just as bad as Mr. Almazeedi, or whatever way that my learned friend would want to put the case. There is a real distinction, and the fair-minded observer will look at each with some care and see whether it is possible to support the case which is being made in relation to Mr. Almazeedi, that somehow he was involved in this litigation. He was no more involved in this litigation than the chairman of the board of any large company would be in litigation before the courts in this country. He might be, but the fact that he holds an office, particularly an office at the very high level, is not necessarily a fact from which one can draw an inference that he's dealing with the day-to-day questions of how QNB should conduct its limited role in the winding up petition. So we respect the Kamal case doesn't work. My learned friend then took your lordships to a number of factors in relation to the fair-minded observer, which he says the Court of Appeal did not give sufficient weight to. And that's what he says in paragraph 22 of the respondent's written case. It's not followed through as to which in particular the Court of Appeal failed to take account of. But this seemed to be part of his case, that never mind Mr. Kamal or Mr. Almazeedi, he had enough to give rise to an apprehension of a real possibility of bias on the part of the fair-minded independent observer just by virtue of the appointment of the judge as a supplementary judge in control and as the judge in dealing with the petition. And my learned friend's written case at paragraph 23 sets out the points which he says the fair-minded independent observer would have in mind. And that's at page 16, the written case at 1621 of the bundle, and paragraph 23 is at 1630. But first of all, one has to have in mind what are the characteristics of the fair-minded observer. He is in many ways a character to whose characteristics what we would all aspire, and each case and every case is fact-sensitive. Each factual situation brings out further characteristics of the fair-minded observer. But we do submit that the fair-minded observer will have an eye for detail, not going to take a very broad brush approach. And there's some helpful guidance in relation to the fair-minded observer in the case of Hello, which is at tab 14 of the authorities bundle, which starts on page 1904. Very broadly, the fair-minded observer is constitutionally balanced, but there are some particular observations which, in our respectful submission, are helpfully set out in paragraph 2 at page 1906. The observer who is fair-minded is the sort of person who always reserves judgment on every point until she's seen and fully understood both sides of the argument. She's not unduly sensitive or suspicious, as Justice Kirby observed in Johnson & Johnson. Her approach must not be confused with that of the person who's brought the complaint. The real possibility test ensures that there is a measure of detachment. The assumption that the complainer makes, assumptions the complainer makes are not to be attributed to the observer unless they can be justified objectively. She's not complacent either. She knows that fairness requires that a judge must be and must be seen to be unbiased. She knows that judges, like anybody else, have their weaknesses. She will not shrink from the conclusion if it can be justified objectively that things they have said or done or associated with may make it difficult for them to judge the case before them impartially. Then there is the attribute that the observer is informed. It makes the point that before she takes a balanced approach to any information she's given, she will take the trouble to inform herself on all matters that are relevant. She's the sort of person who takes the trouble to read the text of an article as well as the headlines. She's able to put whatever she's read or seen into its overall social, political, or geographical context. She is fair-minded, so she'll appreciate that the context forms an important part of the material, which she must consider before passing judgment. In our respectful submission, those characteristics of the informed observer justify a gloss that we would make on it, which is that the informed observer does have an eye for detail. The informed observer will not be satisfied with broad brush suggestions of involvement in proceedings without knowing a little bit more about whether it's actual or simply attributed involvement. And certainly the fair-minded observer would not adopt without careful consideration the statements that Mr. Almazeedi makes about what happened before the petition and then what happened during the course of the petition proceedings. And in our respectful submission, she would not treat petition proceedings between an entity like the QIA, which is a government investment body, as litigation between its individual officers and the company, unless the facts justified that. Equally, she would not treat as involved in proceedings between a corporate entity like the QIA or the QNB as being proceedings between individuals who are officers of those companies, unless there was information to justify that. She would not, for example, proceed on the basis of no smoke without fire or guilt by association, because that would be too broad brush. And with those characteristics in mind, looking at the matters which are referred to in Malone Friend's written case, paragraph 23 at page 1630, the statement made there is that the judge's situation as both the justice of the FSD in the Grand Court and the judge of the QIC DRC, I think it should be, is highly unusual. Well, so far as the authorities are concerned, the Court of Appeal said that this was a novel case. But so far as jurisdictions like Cayman and the Bahamas, the Turks and Caicos, the Channel Islands, Singapore, and then the various courts which have been set up in the Middle East, it's not particularly unusual to have judges who are retired judges in their home jurisdiction with, if I can put it this way, a portfolio of different appointments. In fact, in this self-same case, as we've heard already, when the case first came before the Court of Appeal, the question arose as to Sir John Chadwick's appointment as a judge of the court in Dubai, and the fact that there was a party in these proceedings, the Dubai Islamic Bank. Well, my lords, we respectfully submit that that's not a particularly unusual point. It's a point which we looked at, but it's not immediately a point that will have any greater status than any of the other factors that the fair-minded observer will take into account. We would respectfully submit...
Was the Court of Appeal right? I know it didn't attach legal consequences to this, but was it right to treat, to say that Sir Peter Creswell ought, whatever the legal rights and wrongs, or one would have expected him, whatever the legal rights and wrongs, to disclose his Qatar involvement?
Well, the Court of Appeal deal with this in two places, and my learned friend has referred to the passage later in the judgment. Earlier in the judgment, Sir Bernard Ricks does deal with this point, and at paragraph 50, he deals with it in this way, page 17. We consider the judge ought to disclose his appointment to the QIC-DRC in a case which involved Qatari government interests in the form of the petitioning preference shareholders. That's independent of our decision on this appeal. The purposes of such disclosures, which often go beyond legitimate concerns as to independence and impartiality, which would, subject to waiver, require a judge to recuse himself, is to enable the parties to consider the disclosures made in either to assure themselves in advance that there's no legitimate problem, or to make submissions to the judge, or to finesse any potential problems. Such matters can only efficiently and safely be handled in advance. Once judgment has been entered and the winner and the loser emerge, the matter becomes more difficult. Losers feel aggrieved, whatever the rights and wrongs of the situation are. Specious claims to bias may be raised, etc.
Yes, well, this is prudent advice. I wondered whether you were quarrelling with that.
Well, no, we don't quarrel with the proposition that it would have been something to mention.
Yes.
But on that precautionary basis. And
yes.
Sir Bernard Ricks then went on to cite a passage from the judgment of the Court of Appeal in Lockerbale, where it is set out in paragraph 51 of the judgment. If objection is then made, it will be the duty of the judge to consider the objections and exercise his judgment upon it. He'd be as wrong to yield to a tenuous or frivolous objection as he would to ignore an objection of substance.
I mean, it does strike one, just putting oneself in the position of the judge at the end of 2011. I don't know how long he'd been on the Cayman Island court. Do you know that? Yeah, there he is. He's...
We'll check, but we think it's a matter of years. He's not a
2009.
2009.
Yes.
Right.
Paragraph 23.
He's assigned a case as a Cayman Islands commercial judge just at the time when he's being appointed to Qatar. And on the face of it, one would think, Well, that's interesting. Does it? And he knows he's going to go out to Qatar and be sworn in, and so on, where he's going to meet a lot of people. Had he been to a previous Qatar forum?
I think
yes.
a law conference in Qatar.
Yes, so he knows the sort of thing that happens there. All sorts of people are present, and you meet all sorts of people. I mean, it does. My own feeling is that the Court of Appeal, which you don't quarrel with, has identified a point which one would have expected the judge to be actually conscious of and to think about at that time.
It would be unrealistic to submit that it was a matter of no moment at all.
Yes.
And because that would involve saying that Sir Bernard Ricks was wrong to make the points he did about his relationship with Qatar and the possibility of an appointment in Singapore, or that Sir John Chadwick raised in relation to his role in Dubai.
Yeah.
My Lord Sumption made the point that there are two inferences one can draw from it. One, that it just simply wasn't present in his mind at all, for whatever reason, or that it was deliberately concealed. And if one looks at those two options, the fair-minded observer, I'm sure, would go for the former rather than the latter.
Well, deliberately concealed is a pejorative way of putting it.
But it involves thinking about it and deciding not to.
Well, I suppose there are three possibilities. One, it never occurred to him. Two, he didn't think that anybody could suggest that that gave rise to bias. And three, the more sinister implication that you've just been discussing, which I was most unlikely.
Three is, yes. But advancing three is a likely one.
The precautionary principle is one which we can't say it would be wrong in this case. It would be unrealistic.
So basically, either he missed something which seems to have struck the Court of Appeal as fairly obvious, or else he misjudged it, having thought about it.
Yes, and the Court of Appeal's view, which in our respectful submission is right, would have been that as at November 2011, if the matter had been raised, he would not have considered that there was anything which gave rise to a real possibility of bias and that there would be no reason to recuse himself. And the Court of Appeal's view is that had it been raised later, in June 2013, when Mr. Almazeedi is in the saddle as the Minister of Finance, then the equation would have been a different one.
Mr. Trujillo, you've prevaricated slightly in answer to Lord Mance's question, do you dispute that Sir Bernard Ricks was right to say that he ought to have disclosed it? I looked very carefully at your case.
Yes.
You don't dispute that?
No, we don't dispute it.
Very well.
I think it's unrealistic to dispute it.
It is.
We invite attention to paragraph 50 and 51 as to the context in which that disclosure should have been made. and we noted in our written case that my learned friend refers to a later part of the judgment where they come back to this question. And it's important to put that in the context of paragraph 50 and 51. But in our respectful submission, it would be unrealistic to say no reasonable judge would raise this matter.
At the outset, actually.
When he's first got parties in front of him.
Right. When he was first instructed or first asked, it was given to put it on his dossier. Yeah.
Yes, there would be an occasion for that disclosure, and our respectful submission, making any other submission would be unrealistic.
Yes.
But we do pray in aid what Sir Bernard Ricks says in the passage I've just taken your lordships to. So far as 23.5, in the learned friend's written case, he says a fair-minded observer would know that the subject matter of the dispute involved Qatari entities and persons involved in the Qatari government at the highest level. We respectfully submit that the fair-minded and informed observer would be a little more pedantic than that. He would look at the record and he would say, well, this is a case that involves two petitioners, which are investment arms and have connections with the Qatari government, and a company which is in Cayman. Unless there were very special reasons to do so, the informed observer would not conflate those companies with the persons who were officers of those companies, unless there was a very good reason to do so. Unless there was
Sorry, which passage were you referring to?
It's on page 1631, my lord. It's subparagraph 5 of paragraph 23. And it's really part of our submissions to try to sharpen the focus a bit on what we respectively submitted before the court in November 2011.
Yeah.
And part of what my learned friend is doing by seeking to widen the scope of parties involved and we don't seek to impose a formalism on the analysis of what was before the court or take pedantic points about companies being different from persons. But if one is going to identify a company with a particular person, one has to have a good reason for doing that. Paragraph 23.5 in our respectful submission is part of the flaw of Merlin and Friends' case, which is it is to paint the picture with as broad a brush as possible and to hope that by doing that one can include as many possible flaws in the approach of the Court of Appeal. And in our respectful submission, what was before the court in 2011 was petitioners and a company. There was a director of the company who was the sole director and gave evidence. But this was not a struggle for control in the usual sense, where one has two bodies of shareholders who are struggling for the direction of the company. Mr. Almazeedi had no stake in the company beyond his contractual interests as the manager and the owner of the manager. So he had no right to control economically. He had, as the structure was set up, control through the manager, subject to providing information to the preference shareholders so they could monitor what was happening to their investment. And we obviously accept the fact that there was a Qatari party before the judge is relevant, but that the fair-minded observer is going to look a bit further than simply a Qatari party and a judge with a position as a supplementary judge in Qatar, and is going to be more analytical about what, if any, conflict there is. And in our respect for
many takeover bids are said, aren't they, to be fought bitterly because the directors are really defending their own managerial position rather than their shareholding interests. They obviously put their case forward as a case on behalf of the current shareholders, but in reality, you can have a very vigorous dispute involving a manager and shareholders or outside bidder.
Normally only if there's a supporting equity holder in the company who is behind the management. What would normally happen would be two sides forming between those with a financial interest.
But mightn't they, I mean, the directors, it would be appealing to the existing shareholders to support them. They might be going to fail entirely to get their support. They wouldn't necessarily have any such support. They might think that they could gain it, and they might actually be motivated to some extent, subconsciously at least, by their own position.
They might be, but they would have to make a decision at some stage as to whether the position they were taking was in the interest of the company. Right. There comes a point where if you're going to ask as a director of the company to pay the costs of your opposition to a petition, you're in very dangerous territory. And in a case like this, where one has a substantial percentage of the preference shareholders supporting the petition in the first place, and by the date of the hearing of the winding up, when the winding up order was made, the entirety. So far as that director is concerned, it's game over.
Yeah, because there isn't any shareholding interest to put forward then, isn't that the position?
He had no shareholding interest.
Yes, I know, but he can't appeal to any other shareholders because the entire...
exactly.
The ordinary voting shares don't have any relevance at all, is that right? He held them at that time. But
they would have, the only relevance the ordinary voting shares would have had, they had no economic participation.
I see. No, it's ordinary shares. Okay.
The articles provided that if there was, after a period of time, a particular level of return,
right.
there could be a participation, but that at that point had never been reached. It's never been suggested it had been reached. So the ordinary shareholders did have the voting power. And so, for example, the QGen, as the ordinary shareholder, could have authorised Mr. Almazeedi to defend, or to give him locus to defend the petition, if the company didn't want to. But the ordinary shareholders really, in the context of the petition, had no role to play. And they were present at the hearing on the 26th of January by Mr. Almazeedi. But their interest was, if I can put it this way, vestigial so far as the interests that bit on the winding up petition. On page 1632, my learned friend's written case, which I think is the second subparagraph 2.
Yep.
I've already made my submissions on this, but the significance a fair-minded observer would attach to Mr. Kamal being the Minister of Finance is in our respectful submission.
Right.
In our written case at paragraph 53, we set out a list of competing things that the fair-minded and independent observer would have taken into account.
Sorry, paragraph?
It's paragraph 53 of our written case, my Lord, it's page 1662. In the small bundle, my Lord, it's at tab 6, 1662. And to a certain extent, these are points which I have mentioned already, and I don't want to go over again, but we make the point that the petition was not the continuation of the earlier proceedings between the directors, Mr. Almazeedi and his co-director. So far as the judge is concerned, at little d, we do respectfully submit that the question of the character of the judge in this case is important. It's not a decisive factor, but we respectfully submit that the Court of Appeal, what they said at paragraph 83 of the judgment, were entirely fair and entirely correct. My learned friend took your lordships to Prince Geoffrey, and there's a paragraph in Prince Geoffrey where Lord Bingham, I think at paragraph 21, is referring to the Chief Justice in Brunei as being a man for whom judicial ambition was spent and whose only consideration would be his judicial reputation. The Court of Appeal, interestingly, in our respectful submission, rightly took the view that if there was a spectrum of cases for apparent bias with Miller and Dixon on one end and Prince Geoffrey on the other, this case was closer to the Prince Geoffrey case. And although my learned friend made a number of distinguishing points about the Prince Geoffrey case, the Court of Appeal were completely right in this case to make the point that so far as the position of the Chief Justice dealing a case that involved directly the dispute of the Sultan of Brunei and his brother, that was a very much greater, if I can put it this way, closeness of the judge to the issue and to his employer than is the case here. And the Court of Appeal deal with that in paragraph 83. The distance, if I can put it this way, between the subject matter of this dispute and the Qatari government, a much greater distance than existed between the Chief Justice and the Sultan in the Sultan of Brunei case. Just returning to our written case, we set out a number of matters in relation to the company, at little e to little g, which we respectfully submit the fair-minded observer would have had in mind. And at little I to k, we set out the state of play as it was at the hearing of the petition. And in our respectful submission, these points have already been covered, but at the stage of the winding up petition, all the parties before the court wished for one outcome, which did not require the judge in making any decision beyond that of actually making the winding up order, because only he could. It's not something that could be dealt with entirely by consent. But it was dealt with by the judge with the consent of all the parties, and after a discussion and analysis of the issue he had to determine, which was extremely brief and essentially recorded the fact that there was no opposition to the decision and a good basis on what was common ground between the parties for making the winding up order. We respectfully submit that the QIC DRC is a little u. It is an international court. My learned friend took your lordships to a report of the UN rapporteur in relation to the domestic courts in Qatar. That was a report only about the domestic courts, which in our respectful submission occupy a different status from the QIC-DRC, which was set up very specifically, not for the purposes of domestic litigation in Qatar, but for the purpose of international litigation, and set up in order to be attractive to an international financial market. And we respectfully submit that the fair-minded observer is likely to be able to observe the difference between a government entity, which is an investment arm of a government, and the executive. Of course, these areas can be blurred, the distinctions are not absolute, but the informed observer would want there to be objective evidence that these government entities, which were the petitioning creditors in this case, were themselves connected with any part of the executive that was responsible or concerned with the appointment of judges, and whether that concern was realistic. Because the petition was based on the sort of points that an investment advisor or an investment manager would be concerned about. They were to do with the detail of the financial performance of the company. There was, in our respectful submission, a complete distinction between the sort of points that we were informing and driving the petition, which were real and objective, and the sort of decisions that might be made by the executive in other branches. Qatar is a very rich state. This is a very small company for Qatar. It is unlikely that at the highest levels of government there was any interest in the detail of this case.
What about the point that Mr. Al-Hamadi evidently viewed it in terms of a slightly apocalyptic terms, a fight with the state of Qatar and so on, and he's a very well-connected chap.
Yes, well, those words, I think, were the words which are attributed to Mr. Longmate on the plane.
Yes.
In our respectful submission, the fair-minded observer is going to be a little bit careful about attributing the words of an excitable legal representative to the petitioners as a whole. My lords, the evidence is there. The allegation is made. It's not accepted, but we don't know. We don't have any evidence to put in, as the Court of Appeal observed, we don't have any evidence to put in contrary to that. But on the basis of
Mr. Longmate was swearing a lot of affidavits on behalf
yes,
of
he was
your
legal
clients,
counsel for the QIA.
or rather on QIA, yes.
Yes, so he was a legal advisor for QIA. So,
Yeah.
and Mr. Almazeedi's role in QIA is as a director of the investment board.
Yeah.
Well, those matters which we draw attention to would lead the fair-minded and informed observer to conclude there was no real possibility of bias, certainly at the stage where the winding up petition is being heard, or before. And of course, after the winding up order is made, the preference shareholders cease to be parties involved in the proceedings that follow. Their role is essentially as investors who have an interest in returns out of the liquidation. But any decisions that have been made after the appointment of the joint official liquidators are decisions which the joint official liquidators will make. Any claims...
Would they make them after consulting the shareholders?
There will be a liquidation committee, and one can be sure that the principal petitioners would be on the liquidation committee. And the liquidation committee would probably be asked to approve fees and matters of that kind. So the preference shareholders don't vanish from the scene.
No.
But the joint official liquidators are independent professionals
Quite.
who have to answer to the court. And if Mr. Almazeedi thinks the joint official liquidators are doing something wrong, he can go to the court and complain.
I mean, in a voluntary liquidation like this, the petitioner's influence would be rather greater than it would in a
Yes, yes, it would, because there wouldn't be the court, as if I can put it this way, a mediator or a means of resolving differences between the liquidation committee and the petitioners. But in Cayman, certainly there's a procedure by which a voluntary liquidation could be subjected to the supervision of the court, at which point the court would then have a role. But from the date of the winding up order, the issues turn from being issues between the company and the preference shareholders to being issues between the joint official liquidators and Mr. Almazeedi, and the decisions that are then made are made on applications made by the joint official liquidators. And as we know, there were really only two significant orders which were made. One was an order for the provision of information, which in a sense is water under the bridge, so far as whatever happens on this appeal. And the other is the court's determination of the liquidator's rejection of Mr. Almazeedi's proofs of debt. But at that stage, it is absolutely clear in our respectful submission that the informed observer would look at the issues which were falling to be determined and say, well, these are not issues between Qatari entities at all. These are issues between liquidators who have a role as court-appointed liquidators, who have duties under the company's law, performing those duties properly or not. And if Mr. Almazeedi thinks they're not performing those duties properly, he can go to court and complain. So in our respectful submission, the fair-minded observer would take account of what we would respectfully submit are the objective realities of the nature of the litigation, the fact that this litigation moved from the winding up petition to the order to then a different status of litigation between different parties, and will conclude that there was no real possibility of bias at all. Maloney Friend refers to unconscious bias, but in our respectful submission, of course one knows about unconscious bias, but Maloney Friend's a little vague about what the unconscious bias is really doing in this case. And so we respectfully submit it doesn't add anything to the argument. I've dealt with the point about the judge's oath and his distinction. So far as Maloney Friend's point that it's just not the way things are done, judges are not expected to decide in one jurisdiction disputes involving persons who are responsible for their appointment in another jurisdiction. We would make the following submissions. Obviously, judges deal in their home jurisdiction with cases involving the executive. And the answer to that is, well, that's no problem, because judges are immune, effectively insulated from any pressure, and they are irremovable. Of course, Maloney Friend makes no complaint about the level of protection which Mr. Justice Cresswell had in Cayman, but he makes complaint about the position in Qatar. But again, he paints the picture with a very broad brush, because the way he puts it is one wouldn't expect a judge to decide disputes involving the persons who are responsible for their appointment, and one has to step back from that in our respectful submission and say, well, is that really made good on the facts? I think the first place we have to look is law number 7, which is in the authorities bundle at tab 5, pages 1695 to 1696. And the Civil and Commercial Court is the name which was given prior to its becoming the QIC DRC. And the relevant paragraphs, paragraph 4, which provides for the chairman and members shall be appointed, that's the judges, for 5 years renewable terms, a decision of the Council of Ministers upon the proposal of the Minister, who is the Minister of Finance, shall determine the terms and conditions of their appointment and remuneration. Then paragraph 5 states that the judges shall enjoy the due independence and impartiality in performing their duties. Neither the state, the Council of Ministers, the chairman, the QFC authority, the regulatory authority, nor any other person or body may intervene in the course of their decisions. And then 6, the chairman and any member of the Civil and Commercial Court may be removed by a decision of the Council of Ministers. And then relevant here is C, the Council of Ministers, if the Council of Ministers is satisfied that he's been guilty of serious misconduct, which in either case the Council of Ministers considers to be of a nature which warrants his removal from office. And the law is silent as to who actually makes the appointment in the first place. It's clear that the Council of Ministers deal with the terms and conditions of the appointment, and they can remove judges. And we accept that the level of protection which is given by this law is less than the level of protection that is given to the judge in Cayman or here. But what the law is silent about is as to who is responsible for appointment. But if one assumes that appointment is dealt with by the Council of Ministers as well, but one doesn't see in black and white any provision that provides that the finance minister is himself responsible for anything other than proposing the terms and conditions of the appointment of judges. Everything else is done by the Council of Ministers. And in our respectful submission, this is another area where the fair-minded observer is going to look at the Mullin and Friends case and say, well, are these really persons involved in the petition who are responsible for your appointment in another jurisdiction? Law number 7 doesn't, in our respectful submission, go that far. It really gives the power to the Council of Ministers. And it would be, a fair-minded observer would certainly not accept that the Council of Ministers was in any way involved in the petition proceedings before the Cayman Court. The Court of Appeal dealt with the question of security of appointment in paragraph 88, where they said, in making their conclusion, which we respectfully submit is completely right, as at the time when the winding-up order was made, the fair-minded informed observer would have concluded it was not uncommon for a judge to have to deal with litigation in which the government of the country in which the judge was interested, and that the interests of the government of Qatar were directed to the promotion and not the undermining of the QIC-DRC. They would have noted the less than perfect arrangements concerning the removal of judges in the UN report, but would have concluded that the very distinction of the judges that had been appointed to the QIC-DRC and the interests of Qatar in the success of its still new international court would have been in favour of confidence rather than doubt in the constitutional proprietors of the court. And that, in our respectful submission, is exactly how a fair-minded observer would approach it. He'd look at it in the round, look at which court you're dealing with. And what the UN Rapporteur General said is obviously of concern in relation to the domestic courts in Qatar, but it doesn't really have any application to the QIC-DRC, which is effectively an imported international court, which is intended to promote Qatar to the world rather than to serve the interests of the government domestically. I dealt with law number 7. Melenfren runs an alternative case in relation to Article 7 of the Cayman Islands Constitution, and I touched on this briefly before lunch. We respectfully submit that Article 7 is a good way of testing the case on apparent bias made by Mr. Almazeedi, because Article 7 requires a determination of a person's legal rights by an independent and impartial court. And if Mr. Almazeedi were to formulate his case under Article 7 and succeed, one would expect, well, it would be very surprising if the case could be successfully formulated in relation to apparent bias, but fail in relation to Article 7. They cover the same ground, and that's how I understand the appellant's submissions to be formulated.
There might be a difference in respect of whether it concerned a civil right of the individual.
Yes, it could be a criminal right, or it could be
civil or criminal.
Yes.
Yeah.
But it would still be a right of the person making the complaint. If Mr. Almazeedi were to invoke Article 7 and say there's been a breach of the Constitution, my right was determined by a court which wasn't independent or impartial, he would have to point to the right that was determined. The fact that the court was not independent or impartial wouldn't engage in the abstract. It couldn't be raised by Mr. Almazeedi on behalf of somebody else, because, of course, that person has a right to waive, in his own interest, his rights under the Constitution. So if one asks oneself in the context of the decisions made in this case, how would Mr. Almazeedi frame his case under Article 7? He would have to say, in relation, for example, to the winding up order, my rights in relation to the company were determined by the court in the winding up order. But that, in our respectful submission, wouldn't work, because he has no rights in relation to the company. He has contractual rights which are preserved and not affected by the winding up order. Certainly when you get to the position of the orders made on applications by the joint official liquidators, one can say exactly, he can say, well, my right as a director not to disclose information was determined by a court that wasn't independent or impartial, and I wish to complain. It's very difficult to see how he can do it in relation to the petition proceedings, because the engagement of the bias is not with any determination of his civil rights. It's only at the point when the JOLs are appointed that there is a direct issue and a direct question of whether Mr. Almazeedi has a right to withhold information or limit his disclosure obligations, or his rights as to the contractual obligation of the company to pay him money are determined. And we respectfully submit, although the Article 7 case is dealt with very sketchily, the fact that Mr. Almazeedi would have real difficulty in articulating a case under Article 7 must give rise to real difficulty to make a case for apparent bias, certainly in the context of the winding up proceedings and the orders which were made in relation to the asset swap agreement validation order and the winding up order, which were as between the company and the petitioners. Conscious of time, my lords, I just want to deal with one other major point, if I may.
How are you doing?
I'm doing well. I'm just really one major point, and then just...
Yes, I mean, we allowed, or I allowed Mr. Guthrie to go on for a substantial period, and you've
Yes.
gone on
I'm
for a
beginning to trust
pretty
this.
substantial period.
Yes, I have.
You're about a quarter of an hour. I think Mr. Guthrie had 20 minutes.
Yes, I'll be within, I think, the next 10 minutes, if that's...
Yes, well...
Maloney Friend relies on Miller and Dixon, the absolute nature of the right to an independent and impartial tribunal. And of course, he relies in relation to that case on the guilty plea, and I think draws an analogy between a guilty plea and a consent to the making up of a winding up order. And leaving aside who's giving the consent to the making up of the winding order that's the company of Mr. Almazeedi. We respectfully submit that one has to read Miller and Dixon in its context. And of course, what Miller and Dixon didn't involve was any investigation as to whether there was apparent bias. It wasn't concerned with the question of apparent bias because that had been determined already in Stars and Ruxton. So in a sense, all the apparent bias questions have been resolved in Stars and Ruxton, which is in the authorities bundle, I think, at tab 25.
Yes.
At 23. And so by the time the court was considering in Miller and Dixon the issue, it was considering what were the consequences of a determination of an issue by a court that was not independent or impartial. And the argument that, as I understand it, was being made by the prosecutor was, well, we accept Stars and Ruxton was right, but really, if you look at the decisions, there's nothing wrong with them.
Well, it was principally waiver, wasn't it?
It was principally waiver, yes, because I think...
But you're right, there was also...
If we just look at Miller and Dixon, which is at 2023 to 2056, tab 19. A number of points were raised. One of them was, well, Stars and Ruxton was different because the issue was raised before the court had actually made a determination. Everything was different if you were raising the independent impartial tribunal point afterwards. And that was rejected. And what the court was being asked to do was to uphold the orders made by the tribunal on a number of grounds. And one of them was waiver. And the other, which the court found that there was no waiver. And the other, we look at paragraphs 15 and 16. Page 2031, paragraph 15. paragraph 14 recites the argument of the appellants, which was the act of proceeding against them was null and void and without legal effect. In paragraph 15, Lord Bingham says, the Solicitor General sought to rebut this argument by distinguishing stars, essentially on the ground that the challenge in that case had been raised at a relatively early stage of the proceedings, before the trial had been concluded. Thus, the court had no public or other interest to balance against the defect in the qualification of the temporary sheriff before whom the trial was proceeding. Judgments in that case, he rightly submitted, didn't attempt to weigh the interests of the public against the interests of the accused, doubtless because no argument was directed to that issue. But it was plain, this is the argument, that rights under Article 6, save for the right to a fair trial, were not absolute. And then just above letter B, the ultimate issue was one of overall fairness, viewing the proceedings as a whole, which could be done in these cases but could not be done in stars because of the early stage in the proceedings at which the devolution issue had been raised and determined. In making these submissions, the Solicitor General relied on recent observations in Brown and Stott. And then Lord Bingham sets out the particular facts, and in particular, just after letter C, makes the point that one of the appellants, Payne, had pleaded guilty. He says it made no practical difference that her plea was tendered to a temporary sheriff and there was nothing to suggest her sentence was excessive, and then goes through the other appellants. Paragraph 16, with these last submissions of the Solicitor General, I have much sympathy. There is indeed nothing to suggest that the outcome of any of these cases would have been different had the relevant stages of the prosecution been conducted before permanent instead of temporary sheriffs. There's no reason to doubt that the conduct of all the temporary sheriffs involved was impeccable, and no reason to suppose that any of the accused suffered any substantial injustice. But I cannot accept that the outcome in stars would have been different had the challenge been raised after the trial in that case was concluded, and it's in my view clear from authority that the right of an accused in criminal proceedings to be tried by an independent and impartial tribunal is one which, unless validly waived by the accused, cannot be compromised or eroded. Just on the point of the guilty plea, Lord Bingham returns at paragraph 27, where he says, I accept the argument that the right to a fair trial is a safeguard which shouldn't, least of all in the criminal field, be weakened or diluted, whatever the administrative consequences. I accept the argument for the accused on this point. The Lord Advocate had no power to act in a way which infringed any convention right of the accused. By continuing to prosecute the accused before a tribunal which was not independent and impartial, he infringed the right of the accused to have the criminal charges against them determined by a tribunal which was independent and impartial. Unless the accused validly waived their entitlement to trial before an independent and impartial tribunal, he acted in a way which Section 57.2 denied him the power to do. I think this is a view taken by the High Court. No distinction is to be drawn between the case of...
Well, we can read it, can we, ourselves? I mean, he points out that the role of a court in a criminal case, even when there's a plea of guilty, is not entirely passive.
No.
Well, in the present case, Sir Peter Creswell found it necessary to deliver a 10-page judgment on the application relating to winding up, during the course of which he pointed out that the company can't sufficiently, or pointed out a submission, that the company can't simply consent to a winding up petition. And he dealt with that by a process of reasoning to the effect that because all the preference shareholders didn't oppose it, it followed it was just and convenient to wind up. So he was exercising a judgment about the matter. Can one say that this is completely inconsequential?
One can't say it's completely inconsequential, but there is no, if I can put it this way, no balance being...
There's no balance because Lord Bingham says that this isn't a question of balance. If there is a judicial decision of any sort, the only exception to the principle that it should be by an impartial and independent tribunal is waiver.
But the point in Miller and Dixon was that there was no issue as to whether the tribunal was independent or impartial. That had already been determined. If I can put it that way, that was in the bag, and so there was nothing else to argue.
What you say that whether a tribunal is independent and impartial can vary according to the extent to which it has to make a judgment on some relevant judicial issue? Well,
we respectfully submit that where, as distinct from Miller and Dixon, there is no finding that the judges lacks independence or impartiality, then the inquiry which is done if I can put it this way, to see whether the Porter-McGill test is satisfied, is an inquiry which can take into account what actually happened. And we respect...
I think isn't that falling into the fallacy that Mr. Guthrie proposed, namely that to distinguish between actual bias and questions going to independence and impartiality is wrong. Actual bias is a flaw in your independence or impartiality.
Well, there are a number of aspects to that. If Mr. Guthrie is right, that simply by being appointed in Qatar at the time of hearing a case involving a Qatari party in Cayman, that's enough. And the informed observer would say that is enough for me to conclude there is a real possibility of bias. That is right, but if he's wrong about that, then the inquiry in our respectful submission can go wider. And we would respectfully adopt what Sir Bernard Ricks said at paragraph 80 of the judgment, at page 28. If one is considering whether there is apparent bias, one considers, well, what does the apparent bias engage on? What decision was made? And can I, in the circumstances relating to what the judge did, or how he did it, or is there anything on which the apparent bias could engage? I mean, that's a different submission. I've already made that. But what Sir Bernard said, which we respectfully endorse, is it appears to me to be potentially relevant in deciding whether there had been what the fair-minded and informed observer would conclude was a case of apparent bias, that the winding up order itself had ultimately been made without opposition.
It's quite difficult to fit with other bits of this judgment or with the way Lord Bingham puts it in Miller and Dixon, isn't it?
Well,
although it's Miller referred to here.
He was taken to all those cases.
Yes.
In our respectful submission, if he's going to look at all the matters that the fair-minded observer would take into account, that would be one of them.
Right.
And we would respectfully submit the way it was put in relation to Miller and Dixon is distinguishable, because there they were dealing with the consequences of what had already been held to be a tribunal which lacked independence or impartiality. Well, that was to a very large extent, so far as the cross-appeal is concerned. The cross-appeal is, the objective of the cross-appeal was not to find ourselves bound by the conclusion that Mr. Almazeedi made all the difference, because otherwise your lordships could put to me, well, you accept that that's the criterion. We've submitted Mr. Almazeedi doesn't make all the difference. And to a very large extent, all the submissions which I've made to your lordships in relation to the appeal are good for the cross-appeal as well. And the points which I've referred to in paragraph 53 of our case are intended to address this issue as well. We do respectfully submit that the court can take into account what Justice Cresswell put in his perhaps unfortunate letter to the Chief Justice. Because the way that the Court of Appeal dealt with that can be seen at page 899 of the bundle. Page 899, page 899, which is an email from the Registrar of the Cayman Islands Court of Appeal, which followed on the letter from the Chief Justice, page 893. The way it worked is the Chief Justice wrote to my instructing lawyers, attorneys in Cayman, and that letter was then passed on to the Court of Appeal. And the response of the Court of Appeal is set out at page 899. And if it would assist the parties, and your lordships will see that last paragraph, where effectively the information, most of the information that was given in the letter was information which they had taken into account anyway, as something that was dealt with in the course of the appeal. In our respectful submission, this appeal should be dismissed, the cross-appeal should be allowed. Your lordships have been very kind to let me overstay my welcome. Thank you very much.
Thank you very much. Yes, Mr. Clifton. Mr. Clifton.
My Lord, there's actually a typographical error. It's Matthew Goog. But no,
Well,
I have
Mr.
no,
Goog.
I have no further submissions to make.
It was changed.
I'm looking at the wrong one. You're quite right, Mr. Goog. Thank you much. Yes.
In the British Virgin Islands.
Thank you much. Anyway, you have nothing to add. Good. Yes, Mr. Guthrie.
My Lord, I haven't any sort of long campaign in reply. So far as Mr. Kamal is concerned, we would submit that it is wholly artificial to suppose the notional observer would undertake the kind of analysis of his relative position in the QNB, in the Qatari National Bank, in relation to Mr. Almazeedi. The evidence which was before the Court of Appeal did include Mr. Kamal. My original submissions simply referred to the Minister of Finance. You have the skeleton argument there. But in any event, I took you this morning to the part of the affidavit of Mr. Almazeedi where he refers to Mr. Kamal. You'll remember there was a misspelling of his name. And I also took you to the passage at the exhibit at page 708, which deals with his relationship with Mr. Al-Emadi.
Right.
I think your lordships have the point, and it probably doesn't need labouring, but these two gentlemen were not only close blood relatives, but allies and concerned with the same organisations in Qatar as one another. One succeeded the other as Minister of Finance, so insofar as the notional observer would have considered the Minister of Finance's role important, as the Court of Appeal found they would have done, it also applied to Mr. Kamal. It's quite clear that he was involved in the complaint and the response to the complaint about Mr. Al-Emadi. My Lords, the question of the extent of his involvement in Qatari affairs is really confirmed by the exhibit at page 708. I don't know if your lordships would like to look at that again, but
Exhibit?
it's page 708 in volume 2.
Yeah.
This was before the Court of Appeal. And you'll see in the left-hand column, the bank's domestic business model is largely based on receiving deposits from the state and state-backed companies with one hand, lending them back with the other. In this endeavour, Emadi worked closely with former finance minister Mr. Kamal, a close relative by blood and marriage and ally, who supported his rise to the top of QNB. As Minister of Finance, Emadi's relationship with the bank is likely to continue as he is expected to take Kamal's position as QNB chairman. He has also been appointed to the board of the Qatar Investment Authority. See changes at Qatar Investment Authority. My Lord, I haven't been able to find this in the evidence, but one of the developments in your lordship's hearing is that you can be watched on the television. My client is indeed watching you on the television, on the screen in Boston, Massachusetts, which is where he is, and he has sent me a number of messages, one of which, I haven't been able to find this on in the evidence, is that Mr. Kamal was also on the board of the Qatar Investment Authority. Lord, I'm sorry I can't make that good. It's something I can presumably check and confirm. But if so, of course, it puts him as one of the petitioners as well as the chairman of the bank, which owns...
Well, we'd better ignore that unless you can...
Well, my Lord, it may be that I can simply produce some information which confirms it, but...
well, you better agree that with Mr. Fredger, or...
Well, if it's a fact, it's a fact. I have no doubt Mr. Tregear will agree. But, my Lord, in reality, the notional observer is going to realise that Mr. Kamal and Mr. Emadi are very closely involved and would not be likely to make a distinction such as the learned friend has developed. I may have said every bit. I think I withdrew it almost at once when I said he was every bit as involved as Mr. Almazeedi. Perhaps he wasn't every bit as involved, but he was involved in this dispute. And Lord Mance took that matter up with Mr. Tregear. We can see that he was adopting Mr. Almazeedi's point of view and rejecting what Mr. Almazeedi was saying. Lord, the next point I wanted to mention was the question of unconscious bias. It suggested that we didn't nail our colours to what sort of unconscious bias we meant. Well, surely that is largely the point of unconscious bias. We have the fact that Sir Peter Cresswell was, as I think your lordships have observed, really embarking on a further chapter of his judicial career as an extra judge in Qatar. I don't mean any disrespect to him at all to suggest that that was no doubt something which he valued. I think Mr. Justice Cresswell will probably have not been caught by the recent changes in pension arrangements for the judiciary, but no doubt the remuneration that he would be receiving there would be something he would value. As I say, relations with Qatar, put in a very broad way, may well have been operating unconsciously on his mind. If I have to identify such unconscious bias, I don't think I probably do, but obviously one can see the way in which the notional observer's mind might work. Lord, can I then turn to the question? My learned friend made a number of assertions as to...
You know we have to rise.
Yes.
I mean, we've allowed a lot of time.
We're going to be 2 more minutes,
yeah.
if that's...
Right.
He made a number of assertions as to what was likely to happen if the appeal was allowed. Well, my Lord, I would respectfully counsel the board not to pay so much attention to the future, but to look back at the past, because it is, after all, the validity of the orders which were made in the past which are under attack. And I think my Lord has already made the point that what was being done in the courts by Mr. Justice Cresswell was indeed a series of judicial acts. He did deliver a judgment. In relation to the validation petition, the learned friend makes a number of points about it, but the fact is that on several occasions, I have the references, I think. Yes, I won't take you to them, bearing in mind the time, but he made orders
well, we've got
can be found
the
at
full list, yes.
1263, 1411. All of those are judicial acts. And if one looks at the reasons for the policy and the absolute nature of the requirement, it's most neatly set out in Miller and Dixon at paragraph 63. And it's referred to as the fundamental importance of the convention right. The aim being to exclude, this is at the top of page 2048, but the whole of the paragraph is relevant. The function of the right is not only to secure that the tribunal is free from any actual personal bias or prejudice, it requires the matter to be viewed objectively. The aim is to exclude any legitimate doubt as to the tribunal's independence and impartiality. The question of impartiality, actual or perceived, has to be judged from the very moment when the judge or tribunal becomes first seized of the case. It is a question which, at least in a case of perceived impartiality, stands apart from any question that may be raised about the character, quality of any decisions which the judge takes or acts which he performs.
We've got all this.
Well, my Lord, yes, but I simply emphasise that the importance of the principle which we call into effect is the need to look at the tribunal, not at what the tribunal does. But, my Lords, I understand. I'm the last person to wish to outstay my welcome. I was just can't really avoid making the point. My own friend at one stage referred to this as a David and Goliath contest. Certainly my client would nowadays see himself in the role of David. I suppose he'd only hope that the result goes the same way.
Could you just help me on one thing? In your skeleton below, page 136, 11th affidavit is referred to when you say the Ministry of Finance is involved. I don't think we've got that.
I'm sorry, Lord. Can you just take me to the reference?
Page 136 in the bundle, where you refer to the Ministry of Finance in your skeleton below, you refer as a reference to the 11th affidavit, paragraphs 8 and 39.
That's obviously a mistake. Sorry, page 136, one
Yeah.
so.
1A.
Oh, yes. No, I think it may not be a mistake. The trouble is, my lord, that there have been a lot of
All right, well, we haven't got
security.
it.
I don't think you've got it. But that evidence is certainly the evidence that I referred you to earlier.
I mean, maybe between you could hand that in at some
Yes.
later stage, unless it's controversial.
No, my lord, I think it should read first affidavit. Because I think if we go to the first affidavit at pages 2.1, we have paragraph 39, and at page 213 we have paragraph 8, and those are the two paragraphs which refer to exactly that point. So I think it's a typo for first.
Right. Well, thank you very much. The board, that's all you wish to say, I assume?
That's all I wish to say.
Yes. Right. The board will take time to consider what advice it will humbly tender to Her Majesty. We're grateful for the submissions.